Yeah, welcome back, sir. In the last class, we have completed chapter called Bailment, including the revision. So we'll do the scanner. If you can able to answer these questions, you're fit for exam. See, the first question was asked so many times. How many times? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 10 times. Around 10 times this question was asked in the exam as it is. So very, very important. Shivani delivered her old silver jewelry to Mr. White, a goldsmith, for the purpose of making the anklet out of it. This is giving some gold ornament to silver ornament to gold, goldsmith for making the new ornament, that is anklets, gajal. Every evening she used to receive the unfinished good to put it into the box kept at the white shop. She kept the key of the box with herself. See, there's a person called Shivani. Beta. Shivani is there, and there's a goldsmith is there. So she's giving some silver ornament to this guy to make it as a new ornament. That is a anklets. Now, so this goldsmith said we can't do everything in a single day. It will take 3 days. How many days? The same example we discussed, I think. So goldsmith first day he's doing the part of the work. Then he said remaining part we should do in the next day. Then Shivani said, in your shop I'll keep the box. I will lock the box. I'll keep that unfinished ornament in the box. The key is there, but for this key, ये क्या है बेटा? Key. This key, key is there for this box. I'll keep it with myself. Tomorrow I will come. I will open the box. I will give the unfinished ornament. You finish it. है बेटा? So whether it is a bailment, it is not a bailment because we are giving the position to the goldsmith. The same example we discussed. So she kept the key of the box with herself. If key is given to this guy, bailment. Since key is not given, it is not a bailment. So one night the anklet was stolen from the box. Was there any contract of bailment? Question number 1. Is there any bailment? Is there? There was no bailment. So whether the position of the goods are delivered? No. Position is not given to the bailee because keys is with us only. I give you the car example also. So we're giving the car for the bad parking. Keys is with that watchman. It is a bailment. Keys is with us. It is not a. So give your answer with reference to provisions of the Indian Contract Act. This was asked so many times. How many times? Step number 1, delivery bailment means delivery of the goods by one person to another person. Yeah. Delivery to bailee may be made by doing anything which has the effect of putting the goods in the position of the bailee. Here we are not putting the goods in the position of the bailee. So facts, keys are with us only. Therefore, in the present case, there was no bailment. So who should bear the risk of loss of the good? Goldsmith or Shivani? Shivani. Done. Take your pocket. 4 marks will be there. तो नहीं आ रहा सतीश 3 या 4 4 ఉన్నాయి కదా next question was asked once twice thrice 4 times 5 times 6 times 7 times in the exam. How many times? As it is. Look at the screen. So maybe how many marks beta? 4 marks. 2 plus 2 marks. Examine with reference to provisions of the Indian Contract Act whether the following constitute bailment under the provisions of Indian Contract Act. Golu parks the vehicle at the parking lot, locks it and keeps the keys with himself. Bailment is there or not? Because keys are not given to the watchman. Seizure of the goods by customs authorities. So since you're not paying some taxes, customs are seizing your goods. Once you pay taxes, they will give it back. Is bailment is there or not? Deliver the goods by one person to another for specific purpose. Purpose into the payment of the taxes. Once you pay taxes, they will release. Done. Bailment. क्या बेटा? Not a bailment. Bailment is exist. Done. On the basis of the reward types of bailment and gratuitous, non-gratuitous. Gratuitous for the consideration, non-gratuitous without any consideration. Next, as per the provisions of the Indian Contract Act, define the meaning of the continuing guarantee. This we will discuss in the guarantee chapter. Continuing guarantee is very, very important. 5 stars. How many stars? When we come to the topic, you have to tell. Sir, it's a 5 star. How many stars? చెప్తానా Next one is the gratuity bailment. So 2 plus 2, 4 marks. Done. Third question. Next, state the essential elements of the contract of bailment. Essential daily question. There must be delivery of the goods. There must be contract. Goods must be returned. Ownership is not a transferred. It is applicable only to movable property. That is goods, but not a movable property. Done. Next, give the difference between the bailment and the pledge. Bailment any purpose. Pledge only for the purpose of the repayment of the loan. Bailment is broader. Pledge is narrow because subset of the bailment. Next, A hands the carriage from B and agrees to pay 5,500 higher charges. The carriage is unsafe, though B is unaware of it. A is injured and claims the compensation for injuries suffered by him. B refuses to pay. Discuss. 1, 2, 3, 4 times I would examine. I will discuss this example. I am having the SG self-driven car. What is this? Tirupati. What is this? How many mountains? 1, 2, 3, 4, 5, 6, 7 mountains. After reaching 4th mountain, brakes, clutch not working. Yes sir, no sir. Then same example. A hiring a carriage from the B. Agrees to pay 500. Non-gratuitous bailment. The carriage is unsafe. That means clutch, brake not working. Whether I know about this? So B don't know about it. So B is unaware of it. Who's B is the self-driven cars. Done. Then if you listen to my lectures properly, each and every ICA question will be already covered in the lecture. While giving the lecture, I will give beautiful examples. Which examples? Each example carries. Take your pocket. Yes sir, no sir. So whether B is liable? Yes, because it is a non-gratuitous bailment. So what is non-gratuitous bailment? So facts about right. Oh, kharab ho gaya gaadi. So the bailment between A and B is a non-gratuitous. Then B will be liable to compensate A. Same question. A bails his jewelry with B on a condition to safeguard it in the bank's safe locker. However, B kept it in the locker at his residence. A bails jewelry with B on the condition that to safeguard it in a bank. Akila, SG, I gave the jewelry to Akila. I said to Akila, Akila, don't keep this jewelry in your home. Don't keep it at your home. Keep it in the bank locker. Will she listen? No, she don't listen to my class itself. Mad into the pilla. Chance. So I said, keep it in the bank. Akila, keep this jewelry in the bank. But Akila is keeping it at home itself. Whose fault? Daily. Whose fault? However, B kept it in a safe locker at her residence. As the concept Akila, he did it. Where he usually keeps his own jewelry. After 1 month, our jewelry was lost. In a religious rights, they filed a suit against the B for recovery. Can I file a case on the Akila to recover my worth of the jewelry? Yes. Because whose fault? I said I give the bike to mechanic for the repair. For the what that guy is doing? 2 girlfriends and wheeling. Can he do? If I'm getting any loss, you would compensate me or not? In the place of bike, what came? Jewelry came. Every example will be covered. Listen to SG examples properly. Daily has to follow the instructions of the whether she is following? No. He is liable to compensate the A for her negligence. Done. Sunil delivered his car to Mahesh for the repair. Bailer, Sunil. Bailing, Mahesh. Bailed goods, car. Mahesh completed the work but did not return the car to Sunil within the reasonable time. So, repair is completed. It is the It is the duty of Bailey to return the goods. However, in our example, he did not return the car to Bela. So Sunil repeatedly reminded Mahesh to return the car. So he keep on asking, hey Babu, hey Babu, give it back. Paper is completed. No, please return my car. Please return my car. But he's not listening. In the meantime, a big fire accident was occurred in the neighborhood. పక్కింట్లో ఆంటీ వంట చేస్తుంది. ఏం చేస్తుంది? వంట. వంట చేస్తుంది జల్ గయా. क्या जल गया? सब जल गया. Auntie is not that much important, Ganesh. Fire is important. Your focus is different. Big fire accident occurred in the neighborhood and car was destroyed. So who should bear the loss? Mahesh. Bailey. It is the duty of the Bailey to return the goods once purpose is completed. Otherwise, Bailey is keeping the goods at his own risk. Whose risk? Discuss the same example. Last two benches. Sisters, focus. And Raj, this question also came so many times. 1, 2, 3, 4, 5. So many times. How many times? Raj gives his umbrella to Manoj. Who's giving the umbrella? Raj. To whom? Manoj. Who's the Raju? Bela. Manoj? Bailey. During the raining season, to be used for 2 days. How many days, sir? After 2 days, we should return it or not? 2 days during the examination. Since exams is there, rain is coming. So to save you, to protect you, I do the umbrella. Manoj keeps the umbrella for the week. ऐसे कर सकते बेटा? I while going to Raj home to return the umbrella, Manoj accidentally slips. జారి పడ్డాడు. ఏడ పడ్డాడు? Umbrella is badly ఎక్కడో కొచ్చుకొని పోయింది. ఇరిగిపోయింది. ఎక్కడికి పోయింది? Who should bear the loss? Raj or Mahesh? Manoj. Why? He is unable to return the goods within the specified time. If Bailey fails to return the goods within the specified time, Bailey has to keep the goods at his own risk and compensate Bela. If Bela suffers any loss, then came so many times. How many times? Next, in accordance with the provisions of the Indian contract, answer the following. Rights of the bailor against the wrongdoer. Which doer? Third party September 2024 में आया बेटा. So who can file a case in the wrongdoer? Bailor or bailiff both are. So I give the bike car to Akila for the repair. For the so Sahiti was going out of frustration. है ना बेटा? Out of having the fresh air, she's doing the mobile. చిత్రంలో సన్నివేశానికి వెళ్ళం కల్పితం. Break. Yes sir, no sir. Then who will file on Sahiti? Is he and also the Akila. So what he is asking rights to the bailor against the wrongdoer. Can I assume? Yes. Next question. What is the liability of bailey in making the unauthorized use of the goods? Can he use the goods without authority? If he use, it will become voidable at the option of the bailor. Can bailey mix my goods with his goods? With consent? Without consent? If it is mixing, is separable? If it is separable, you have to bear separate expenses. Not separable, compensate. Compensate. This question is asked once, twice, thrice in the exam. Amar bailed 50 kg of the high quality sugar with Srijit. Bailor Bailey, who owned a kirana shop, promising to give 200. Promising to give 200 at the time of taking back the bailed goods. rent adi. So what is 200? Rent for keeping the goods. Same example we discussed. Akila, rice bags, SG rice bags. Sidit's employee, unaware of this, mixing the 50 kg of the sugar belongs to Amar with the sugar in the shop and packed it for sale when Sujit was away. When Sujit is not there, but this guy is not there, no. Sujit, the employee is there, no. Ganesh is mixing. Yes, sir, no, sir. This came to light only when Amma came asking the sugar he had weighed with Sujit. As per the price specification, as per the price of the specific quantity of the sugar he tradable. What is remaining available to Amar? Whether it is separable, a sugar आपका, a sugar मेरा, a particle आपका, a particle मेरा. If daily mixes his goods with Bela without consent, and if it is not separable, daily has to compensate Bela. Done. 4 बार आए एग्जाम में 4 मार्क के लिए. Yes or no? Increase in the profit and cow को कहा है बेटा? Calf. Cook, dog, puppy, shares, bonus shares. Ganesh चिन्ह Ganesh. M lends sum of 5,000 rupees to B on security of the 2 shares. How many shares beta? 2 shares of a limited company on 1st April 2007. On 15th June 2007, the company issued the 2 bonus shares. और shares किसका है बेटा? Original shares है M. Bonuses किसका है बेटा? M इच्छे. So B returns the loan of 5,000 rupees with the interest, but returns only 2 shares which were pledged, refused to give back the bonus shares. Whether B has returned all the shares, 4 shares or not? Yes, because it is the duty of the bailey to return the any increase in the billed goods. Done. This question also came so many times. 1, 2, 3, 4. Stephen owns chicken farm near Gurugram, where he breeds them and sells the eggs and live chicken to retail shops in Gurugram. Gurugram. Mr. Fleming also owns a similar farm in Gurugram, doing the same business. The 2 people are there, one is Stephen, other one is the Fleming. Both are doing that poultry farm business. Which farm? Poultry farm. Fleming had to go back to his native place. Fleming has to go back to native place in Australia for 1 year. He needed money for travel, so he pledged his farm to Stephen for 1 year and received a deposit of 25 lakhs and went away. ऊपर चले गया. ऊपर means Australia. ऊपर से नीचे भी आ गया, है ना? So 25 lakhs. So he's pledging his poultry farm with Stephen, taking the 25 lakhs. Done. So at that point of time, the stock of live birds was 1 lakh and eggs was 10,000. The condition was that when Fleming returns, he should repay the deposit and take back the farm with live birds and eggs. So he said, I will come back, I will pay you 25 lakhs, I will take back my poultry farm. After 1 year, Fleming came back, returned the deposit. So, पैसे दे दिए, 25 lakhs भी दे दिया. At that time, there was 1 lakh 9 live birds increased due to hatching of the eggs out of the 10,000 eggs he had left and 15,000 eggs. So Mr. Fleming agreed to return only 1,000 and only 10,000 eggs. So whether we have to eligible to get that extra chickens are not. Hen is getting chicken. Cub is having the calf. Shares are getting the bonuses. Plant is getting the mini plant. Money plant. Discuss that. But see the length of the question 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 lines are there in my material. In ICA, it will be around 16 to 17 lines. By the time you reach this line, you forget this line, obviously, because you know about your memory. uh, difference between the pledge and the bailment दो बार आया. How many times, sir? A bailer pledges cinema theatre and other accessories with Cine Association Cooperative Bank Limited, the bailey for the loan. So A is pledging the projector with the bank, cinema projector with the bank. A requested the bank to allow the pledged goods remain in the position of the in his position, promises to hold the same interest for the bailey. So A said, I want to keep the projector in my theater itself because I have to play the movies. But if I am unable to repay your loan, you can come and take it. Then, so is keeping the projector as a security, taking the loan, but he requested, I will keep the projector with me only. So every month I will pay the rent, the interest and repayment of the principal. If not, you can come and take back the projector. A requested the bank to allow the pledged goods remain in his position. Whose position? A position. And promises to hold the same interest for the bailey. So you are the beneficiary ultimately. If I am unable to pay interest or the principal, you can come and take it. And also further promises to hand over the position of the same to bank whenever demanded. If I am unable to pay interest, unable to repay principal, you can come, you can take it. Explain the provisions of the Indian contract that decide whether there is a pledge is there or not. Pledge means delivery of the goods by one person to another person. The delivery can be actual delivery. Which delivery? Like a pen. A conditional delivery, like a car keys. The three types of delivery will be there. Delivery, how many types? Three types. Actual delivery, symbol delivery, conditional delivery. Actual delivery means giving the pen. Just like that. Symbolic means car keys is giving a car is deemed to be given. What is conditional delivery? చెప్పిన మీకు క్లాస్ లో మొన్న this will come again. Conditional delivery అంటే ఏంటంటే SG Akila, she is having a warehouse. In Akila warehouse, I am keeping the 100 bags of the rice. How many bags of rice? I sold all this rice to Rajni. I sold all these goods to Rajni. So when I'm selling now, we have to give the position or not. Then I said to who is the seller? SG. Who is the buyer? Rajni. Where is the goods? Akila warehouse. I said to Akila, from next month, Rajni will pay the rent. Then Akila made a call to Rajni. Rajni. Every month you have to pay this much of the rent. She said, yes, sir. Or yes, madam. Whether position is changing, change in the when I am the owner, where is the goods? Akila warehouse. Now where is the goods? Akila warehouse. But Rajni agreed to pay the rent from next month. इसको बोलते हैं constructive delivery. Which delivery? There is no change in the position. There is no change in the but delivery is deemed to be happen. Constructive means implied, assumed, presumed, deemed, causing, constructed, all are similar. These things will come again in SOGA, sales of goods sector. Here, who's taking the loan? A. What he is pledging? Cinema projector. Where is the projector right now? Whether it's in the back or in our theater? Theater itself. Whether position is changing? No. But theater people say, if you are unable to pay your loan, you can come and take it. Which delivery is that? Constructive delivery. Which delivery? చేతిలో పెట్టామనుకో యాక్చువల్ పెన్ అదేమన్నా పెద్దగా ఉంటుంది ప్రొడక్ట్ ఇంత ఉంటుంది ఇంత ఉండదు అంత ఉంటుంది సినిమా థియేటర్ కొనేప్పండి సినిమా థియేటర్ కొనేవా ఇంకా స్క్రీన్ ఉంటుంది వెనక బొక్క ఉంటుంది బొక్కలకి లైట్ వస్తుంది ఆ బొక్కనికి పెద్ద మిషన్ ఉంటుంది చూసాడు ఎప్పుడన్నా అది ప్రొజెక్టర్ విచ్ డెలివరీ ఇస్ దిస్ కన్స్ట్రక్టివ్ డెలివరీ విచ్ డెలివరీ so the delivery can be actual or the constructive. There is a valid pledge. Which pledge? Then this question also came so many times. Twice. 2 times this question also. Next question. Clear a question? Without doing scanner, you can't write the exams properly. स्कैनर को बार बार पढ़ना, ग्रिप आता, सब्जेक्ट को कैसे समझना समझ में आता, इंटरप्रिटेशन आता. So next question beta. This question also came so many times. 1, 2, 3, 4 times. देखेंगे. Yeah. Ravi sent a consignment of goods worth of 60,000 by railways. What is consignment? It's kind of bailment. Consign or consignee. Accounts when chapter will be there. Ravi sent a consignment of the goods worth of 60k by railways and got the railway receipt. He obtained an advance of 30k from the bank and endured and delivered railway receipt in favor of the bank by way of security. क्या बात कर रहे बेटा? कुछ समझ में आया? समझ में आया. There is a person called Ravi. There is a person called Ravi. Ravi is sending some goods through railways. So we are handing over the bag to railways. Bike worth 60k. कितना बेटा? And bike at some rice bags worth of 60k. So railways gave the receipt also. You were 60,000 worth of rices with us. Then Ravi sent a consignment of goods worth of 60k by railways and got the railway receipt. Receipt के ऊपर कितना बेटा price है? 60. My dear Ravi, you were 60,000 worth of rices with us. He obtained an advance of 30k from the bank. Later Ravi went to bank. He's getting the how much beta? 30k. Then as a loan, bank will ask for security. Ravi is keeping that receipt with the bank. What is the receipt value? How much we're taking? What is security? The receipt is a security. He obtained the advance of 30k from the bank and delivered the railway receipt in favor of the bank by way of he gave that receipt to bank as security. The railway fails to deliver the goods at the destination. The railway is not delivering the goods at the destination. Default. The bank filed a suit against the railways. The bank filed a suit against the railways for 60. Decide in the light of the provisions of the Indian Contract Act whether bank will succeed in the case. Bali. Yes or no? Then bank filed a case on the railways. You defaulted. So previously, railways is liable to whom? Ravi. Now railways is liable to bank because this is with the bank right now. Yes or no, sir? So how? What is worth of the rice? Worth of this jewelry that rice 60k. Out of the 60k, bank already gave 30. So can bank file a case on the railways? Yes, but only for 30k. But how much is demanding? Can he? That is the answer. Same example. So, what is the worth of the goods, beta? 60. And how much loan we given by bank? 20. So, if the railways if the bank want to file a case from the railways, how much so only? 20. 40 ఇచ్చేసిందిరా 20. Done. Balance up. Next question, beta. Shruti Shruti acquired a valuable diamond at a very low price by the valuable contract. This is not covered by. We have to discuss this. I left one topic, no beta. Sale by pledge by owners. We'll discuss this later because that will be easy when we complete the soga. That's a good set. Next, Mr. Dana said delivers a rough blue sapphire to jewelry. Sapphire దాన్ని ఏమంటారు? స్టోన్ ఒక స్టోన్ ఏమంటారు? సఫేర్ అంటారు. ఏమంటారు? బ్లూ సఫేర్ అనుకుంటుంది. బ్లూ కలర్ ఉంటుంది కదా, బ్లూ కలర్ ఇందులో ఒకటి, అది సఫేర్. నీలం, ఐ థింక్ నీలం ఇన్ తెలుగు. సో డెలివర్స్ ఏ బ్లూ సఫేర్ టు జ్యువెలరీ, అదే బ్లూ సఫేర్ అంటే నీలం అంటే రిటర్న్ జాతి రత్నాలు అంటారు కదా. మిస్టర్ దానా సెట్ డెలివర్స్ ఏ బ్లూ సఫేర్ టు jewelry to be cut and polished. So to cut it and to polish, the jeweler carried out the job accordingly. So Dana set is giving the particular stone to jewelry shop. The jeweler carried out the job accordingly. So as per instructions of Dana set, he is cleaning the particular stone. However, this word is very very important. However, now Mr. Dana set refused to make the payment and wants his blue sapphire back. The jewelry denies the delivery of the goods without the payment, without the examine whether jewelry can hold the blue sapphire with the provisions of the Indian Contract Act. We discussed, but the provision better. I give the bike to mechanic, repair is completed, but I am not giving the repair charges. Daily has a right to exercise lien on the billed goods until lawful charges are paid. So Dana said give the diamond particular stone as per instructions. I'm cutting that. I'm eligible to get my money or not. Whether this guy is giving the money, so can he return the particular stone? No. డబ్బులు ఇచ్చిండా దానా సెట్? ఇయలే. స్టోన్ ఇస్తానా? ఏమంటుండ్రు? However, Mr. Dana said refused to make the payment, refused to make the, without giving the money, will be return the goods. So he has right to exercise the lien, right to return the goods until remuneration is paid. Clear? Radhashyam borrowed the sum of 50k from a bank on the security of a gold. Radhashyam is there, bank is there, taking the loan of 50k, pledging the gold, pledging the on 1721 under an agreement which contains a clause that a bank shall have a particular lien on the gold pledged. So how much is taking? What we are keeping? Gold ornament ring. Done. Which lien is this? Particular lien. Which lien? Right to return only those goods only services given. Radhashyam thereafter took the another secured loan. Radhashyam is taking another 20k unsecured loan. Which loan? Security is there for this loan? Unsecured loan. 20k from the same bank on 1/8/21 for 3 months. On 39/21, he repaid entire secured loan of 50. This loan is repaid. Loan is, so bank must return the gold. Yes or no? The standard is complete. So we have taken the loan, we repaid the loan also. So bank supposed to give back our gold. So he repaid the entire secured loan of 50k, requested the bank to release the gold pledged with it. The bank decided to continue the lien on the gold until the secured loan is fully repaid by Radhashyam. Bank antundi, I will not give the gold until you pay this 20. Then bank say like that. No, I gave the gold for which loan? Secured loan of 50k. I repaid. You gave me loan. I gave the gold. I repaid your loan. You want to give back my? Yes sir, no sir. This is different, no, but this is another transaction. Then specifically he said it is a particular lien. Lien? Then yes sir, no sir. Bank decision to continue is not valid. Not done. Tatvika. Next, as per Indian contract, answer the following. Pledger, pledgee, Pledge. What is pledge? What is pledger? What is pledging? Three differences are there. What is pledge? Who is a pledger? Who is a pledging? And essentials of the content of the pledge. Define the duties of the pani. 6 marks date question. Define the rights of bailer against the wrongdoer. Duties of the pani. Particularly versus generally date question. What is the status of the finder of lost goods? Deemed to be bailee. Loser is deemed to be bailer. Finder is deemed to be bailee. Yes or no? What are the rights available to finder of lost goods? He can retain the goods. He is eligible for the reward. He can resell. Epudu unable to find the owner, own this fund, unable to pay the lawful charges, and perishable in nature goods. Fourth one, searching expenses exceeds two-thirds of the value of the article. Done. So with this done with the scanned also. So for more videos for RRBs, for question banks, subscribe YouTube channel Srinivas Gupta Law Audit Tax Classes. So share, subscribe and comment. Ganta kuda kottandi. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. Welcome back, sir. In the last class, we were doing the revision of the conduct of agency. We'll do the questions on the conduct of agency. Mitro mere pyari desh vasho focus like a laser. Explain the following as per the provisions of the Indian Contract Act. Meaning of agent, who is acting on behalf of someone. Principal, on whose behalf we are acting. 2 marks. How many marks? And who can appoint the agent? Principal. To appoint the agent, principal must be major, soundman, should not be disqualified by law. Then, so he should be major and soundman. He's not asking who can minor become agent. He's not asking who can appoint the agent. Principal. The principal must be competent to enter into contract. Total 4 marks, 2 plus 2. This question was asked 1, 2, 3, 4 times. How many times? Done. Next, what is the meaning of agency by estoppel? And what are the essentials of the agency by estoppel? He is asking what is estoppel? What are the essentials of estoppel? So we should write what is estoppel, essentials of the estoppel. फटाफट लिखना. कैसे लिखना? Done ना? What is estoppel? The same points without point wise. Whenever essentials comes, no, but essentials definition will be remain set. और definition को टुकड़ा टुकड़ा करें तो essentials आता. Without comma, merge everything. Then will become definition. Done. So what is estoppel? Essentials of the estoppel. Next, Shiva appoints Ganesh as Shiva's agent. Shiva, principal. Ganesh, agent. Shiva appoints Ganesh as Shiva's agent to sell Shiva's land. So why Shiva is appointing Ganesh to sell the land? Ganesh under the authority of the Shiva. Ganesh with the authority of the Shiva appointing Gauri as her Gauri, agent of Ganesh. Gauri, sub-agent. Properly appointed sub-agent. By with the consent of the principal, we are appointing the sub-agent. Afterwards, Shiva, Ganesh under the authority of Shiva, and with the approval of the principal, appointing Gauri as the agent of Ganesh. Afterwards, Shiva revokes the authority of the Ganesh. Then later, Shiva removing Ganesh as the agent. Ganesh as the agent, but not of Gauri. What is the status of the agency of the Gauri? First, who is she? She is a sub-agent. He is asking, who is she? She is a sub-agent. Advise whether said agency shall be terminated as per provisions of the Indian Contract Act. Yesterday we discussed, last No type of dictated right now. Termination of agency will lead to termination of sub agency. Termination. పడుకోలేరా అప్పుడు నువ్వు? Termination of agency automatically puts an end to termination of the sub agency also. Done. I said you keep star also there. Yesterday, if you remember, if you're not sleeping in the class. So, who is Gauri? Sub-agent. Termination of agency will lead to termination of the sub-agency also. ये वाला एग्जाम में 2 बार आना. 4 मार्क. Who is Gauri? 2 marks. What will happen to Gauri? 2 marks. Done. Next question. Explain whether the agency shall be terminated in the following cases under the provisions of the Indian Contract Act. A gives authority to B to sell A land. A principal, B agent. Why A is appointing B to sell the land? A gives authority to B to sell A's land and to pay himself out of the proceeds of the debt due to him from A. Afterwards, A become insane. Generally, if principal become incompetent, agency comes to an end. Yes sir, no sir. What he is asking in the question, but actually, agency coupled with interest, I kept to 8 stars. How many stars? This example we discussed yesterday. X owes 50, X owes to Y 50k, and X afterwards appointing Y asks his agent to sell the flat at the Bangalore. Thereafter, pay himself. Pay. Here he is interested. He is interested. Whether it will comes to an end? No. Agency coupled with interest will not be terminated. Then the same question, but if you observe, amount is not there. That's it. A gives authority to B to sell A land and pay himself. Pay to himself. Since here pay to himself is there, but his agent is personally interested. It is the agency coupled with the interest. It cannot be terminated even insanity of the principal. Then I give one more example also. Kirana shop, 95 lakhs, I will invest 5 lakhs. Vani has to invest. Then coupled with the interest. It cannot be terminated. Why? His interest is like a partner. Agency become irrecoverable. Irrevocable. We can't revoke that. Done. How many marks? 2 marks. Second question. A is appointing B as A's agent to sell A's land. B under the authority of the A appointing the C. So A is appointing B, B is appointing C with the authority of the A. Principal, agent to sub-agent. Afterwards, A revokes the authority of the B. When B is revoked, automatically C will be revoked. Above question. Which question? Above question. So, next question. This was asked so many times. 1, 2, 3, 4, 5 times. How many times? Bhupendra borrowed sum of 3 lakhs rupees from Atul. Bhupendra appointing Atul as his agent to sell his land. Who is in principal? Who is in agent? To sell his land, authorize him to appropriate the amount out of the loan proceeds. How much Bhupendra is taking, beta? 3 lakhs. Yes sir, no sir. So sell the land, you may get 10 lakhs. Out of 10 lakhs, you keep 3 lakhs because I have taken 3 lakhs. Remaining 7 lakh, beta? Give it back to me. The 10 lakhs is not there here. Assume. So afterwards, Bhupendra revoking the agency. Decide under the provisions of the Indian Contract Act whether revocation of said agency by Bhupendra is lawful. Lawful, huh? Unlawful. Why it is unlawful? Agency coupled with the interest. The same question was asked here 7 times, about 2 times. Here 7 times, about 2 to 3 times. Nearly 10 times. If you remember, While giving the regular lecture, I said, star, star, superstar, star, star, mega star, 10 stars. How many stars? So 10 times I. That's why listen to SG classes properly. Done. Sindhu, in step number 1, we should write what is the meaning of irrevocable agency. Here we should write what is happened. Since it is irrevocable agency, principal cannot revoke the agency just like that. It is own wish. Done. Done. Next. Acacia. Acacia Steels. Famous manufacturer of steel products. Proprietor of Acacia Steels, Mr. S.K. Jain, appointing Mr. Satish as his agent. S.K. is the principal. Satish is the agent. Mr. Satish is interested with the work of recovering money from the various traders to whom the firm sells the products. So Satish has to go to every customer and bring the money from the customer, give it to his principal. That is the duty of the Satish. So Satish has earned commission of the 1,15,000 for his work. So he's bringing the money from all the customers. No. So how much we have to pay to Satish? 1,15,000. He recovers the money from the clients on behalf of Acacia Steels. During the particular month, he's collecting the 4 lakhs. How many lakhs? But deposited in the firm's account 2,85,000. By 280 plus 285 plus 150, 4 lakhs. How much is collecting, beta? What is his commission? Remaining, this amount is depositing in the principal bank account. Examine with reference to provisions of the Indian Contract Act whether Satish is valid. Can you do like that? Yes. Moreover, it is the irrevocable agency. Which agency? Which agency? Done. Satish will be valid. Done. Minor as the agent. Appointing M, a minor as his agent. Who is the principal? A is the principal. M is the agent. Agent. As his agent, to sell his watch for the cash at a price not less than 700. Principal said to agent, you have to sell the watch for 700. But वो minor है ना बेटा, इसे को सुनता क्या? नहीं सुनता. A class कहीं ना दो. Will he listen? No. चंदु विंटला माटाडो. इंडु मंटाई पे same. इंडु. So M sold it to D for 350. M sold the goods to D for 350. How much? 350. Is it is valid? Is it is valid? Can minor become agent? Yes. Minor can become valid agent. Yes sir, no sir. Will D get the good title? Will D get the ownership on the watch or not? Yes. Whose fault is that? Principal fault. We shouldn't appoint the agent. Pillow. Then can principal ask the 350 more again from the D? No. So M is not liable to pay for his negligence in the performance. Being the minor, he will not have any responsibilities. Customer will get the good title. Which title? Done. ABC Limited sells its products through agents and it is not the custom in their business to sell the products on credit. So ABC is there. They selling the goods through agents. Mr. Pinto, who is Hubida? Pinto, who is the ABC principal. Pinto is the agent. What is the business strategy? We should not sell the goods on credit. Pinto, one of the agents, sold goods of the ABC Limited to Pratul. He sold the goods to whom? Pratul. Parul. On credit. On credit. Which was insolvent at the time of the sale. Parul is the insolvent. वो बर्बाद हो गया. sued Pinto for compensation towards the loss caused to sale of the products to parole. So ABC filed a case on the Pinto for the not following the instructions. Can ABC file a case on the Pinto? Yes, because it is the duty of the agent to follow the instructions of the principal. If you don't follow, you have to compensate the principal. Yesterday, the same example we discussed. In the place of the that credit, something else we discussed. Then below, where it is? Duties somewhere. I kept star also. Star, star, star. How many stars I kept? One star. One star only yesterday. So that's why it came. One, oh, so many times better. One, two, three, four, 5 times I better. Keep three, two, three stars laga over there. Make it more stars. Sindhu, keep more stars there. Next question. Look at the screen. Look at the screen. Mr. Shiv, a cargo owner, started a vessel to carry cargo of the wheat from foreign port to Tuticorin. Tutti, it's a one of the seashore. I think Goa, nearby Goa అనుకుంటా. Tuticorin అంటే. So the vessel got stranded, stranded. Stranded means helpless in the middle of the ocean on the reef of the sea 300 miles from the destination. Nearly half kilometer from destination, something must happen to that ship. The ship's managing agents signed a salvage agreement for Shiva. So there is a person called Shiva. Shiv is importing something through shipping company. Which company? Then what he is importing? Wheat. पानी में गए तो क्या होता है बेटा खराब हो जाता wheat. Yes sir, no sir. So 300 miles from the destination and still half kilometer is nearly. So something must happen to ship. वो मोटर है ना बेटा इंजन खराब हो गया. It has to make sound बोल के और sound नहीं आ रहा. Sound వస్తుందా? టిక్ కొట్టిండు. దేనికి? చిప్పుకు. స్టార్ట్ అవుతుందా? అయితేలే. उसको बोलते हैं started. So helpless in the middle of the ocean. So to save the that wheat, he entered an agreement with SG salvage agreement. Which agreement? Salvage agreement అంటే ఏంటంటే వాడు salvage agreement recuse or save something from the damage. So SG will come to the SG is in the seashore. He will is having small ships. చిన్న చిన్న పడవలు ఉంటాయి మాకు. So we will go there on our small ships. We will bring back the wheat to destination. Who is entering that agreement? Shipping company. Why? To protect. So how much they will give me? Maybe 10,000. But how much worth of that wheat to 1 lakh? How much they expect spending? 10K. Why he is doing this? To save the principal goods. To save the, he will do the same thing even his own goods. Yesterday someone was sitting here. Who is sitting here? Gautami. Gautami God. Sir, I said no. You have to, we purchase the cloth for 70, we sell it for 100 rupees, profit 30. So something was, fire accident was happened in the shop. Because of that, without my consent, she's selling the goods for less than the purchase price. Someone was sitting here. Gautam Akka. Yes sir, no sir. So Gautam activity valid and valid are perfectly valid. In the place of the cloth, what is it? Wheat is there. Yes sir, no sir. Who is the principal? Shiv. Who is the agent? Shipping company. To save that ship and wheat in the ship, they entered an agreement with SG. Which agreement? Salvage agreement. Which agreement? Then subsequently, Shiv said, I will not give you the 10,000 rupees. Can he recover the money from Shiv? Yes. because it is an agency in emergency. Agency. So the goods being perishable, the solvers stored at their own expense. The solvers intimated the whole incident to the cargo owner. So they informed this how it was happened. That's why we are saving your property at our own cost. She refused to reimburse the salver, as it was the ship owner, being the bailey of the cargo, was liable to reimburse the salver until contract remained unterminated, referring to provisions of the Indian Contract Act. Do you acknowledge or decline the act of salver? Acknowledgement support. Will you support the salver and not support the salver? We support. And as an agent by necessity, he only got the clue also. Then ship is there. Shiva is there, sending the goods through shipping company. Something was happened to ship when it was 300 miles from the destination. So they entered into salvage agreement with the SG. SG's name is not given here. Assume. Some name is not given. No, assume SG in the exam hall. Yes sir, no sir. Can we recover? This SG can recover the money from the Shiva? Yes. Agency by necessity. Agency by emergency. So salver is entitled to recover the agreed amount from the ship, not from the ship owner. Here salver will become the agency by necessity. Agency by or emergency. Same in the place of the bit tomatoes came better. How many times this was asked? 1, 2, 3, 4 times. Rahul, transporter, was entrusted with the duty of the transporting tomatoes from rural farm to city by Ashwin. So who's the owner? Rahul. Who's the auto driver? Ashwin. Who is the principal? Who is the agent? Due to heavy rains, Rahul was stranded ante helpless. ओ वे खराब हो गया. उसमें क्या है बेटा? टमाटास. पेरिशेबल नॉट पेरिशेबल. मोर और बारिश भी आ रहा. And stand for more than 2 days. And Rahul sold the tomatoes below the market price, nearby market, where he was stranded, fearing that tomatoes may perish. Can Ashwin recover the loss from the Rahul? Mhm. Ashwin is the owner. Ashwin is the principal. Rahul is the auto driver. Rahul is the auto driver. Rahul, a transporter. Rahul, a transporter. And now Rahul appointed by Ashwin. So can Rahul recover the loss? Can Ashwin recover the loss from the Rahul? No. In the place of the class, tomatoes came. I told you we purchased for 60, selling for 100 rupees. 70, 100. Selling for the 60 only. Why is he selling for 60? To save the at least 60% of the loss. Then otherwise everything will become zero. Clear? Can principal recover the money? No. Here, this driver will do the same thing even it is his own goods. Which goods? Done. So he cannot recover. This question was asked. ऊपर कितना भरा है बेटा? Thrice. 3, 4, 5, 6, 7, 8 times nearly. Done. Date question beta. Subject by substitute agent 1, 2, 3 times आया. State with reasons whether the following statements is right or wrong. Ratification of agents is valid even if the knowledge of the principal is materially defective. Statement is invalid. Why? Because I said no beta. Example. So principal is ratifying. Owner kept some condition. You have to go for whitewashing. Every year rent will be increased. Students should not standing in the ground floor. Without knowing all these things, he is ratifying. Valid and invalid? Invalid. Materially defective means materially and mostly principal don't know what is happening in the contract. Ratification will be see the question. Only 2 marks. How many marks? Unfortunately. Bharat Hari authorizes Bharat, a merchant in Mumbai, to recover dues from Banke and Co. So Hari is there. Who is the principal? He is appointing Bharat. He is appointing the Bharat. Who is in original agent? Which agent? To recover the due from the bank and Bharat instructed the Deepak, a solicitor, to take the legal proceedings against the bank for recovery of the money. So Bharat said to Deepak, do one thing, recover the money from the that particular company, give it back to Hari. Explain the legal position of Deepak. Here, Deepak is not working for the Bharat. Deepak is working for the Hari. Sub-agent, substitute agent. Substitute agent. Which agent? Yesterday we discussed. If someone is reporting to original agent, उसको बोलते हैं सब एजेंट. Directly working for the principal. Then different provisions of the contract. What is kind of the agency it is? It is a substituted. Same question, kind of. Anuj of New Delhi consigns certain goods to Dharma of Bombay for the purpose of sale by auction. So Anuj is there. Who is the beta? Anuj. Anuj said to Dharma, to take these goods and go for auction. Go for Dharma on receipt of the goods, engaging the auctioneer of the repute Naisik for the purpose of for this purpose and informs Anuj. So Dharma is appointing the Naisik, and Dharma also authorizes Naisik, the auctioneer, to receive the proceeds of the sale. The goods were auctioned and sale proceeds recovered from the bidder Naisik before accounting the proceeds and remitting the same to Anuj. Directly give it back to whom beta? Dharma said to Naisik sell the goods. The same man directly give it to. Which means subject substitute agent. Before accounting the proceeds and remitting the same to Anuj, Naisik become insolvent. Anuj claims the sale proceeds from the Dharma. Anuj file a case in Dharma. Will he win the case? No. Why? He is not a sub agent. He is a substitute agent. Which agent? Anuj claims the sale proceeds from the Dharma. Comment validity. So can he file a case on the Dharma? No. Anuj cannot take it from the Naisik because he is not a sub-agent, he is a substituted agent. We discussed yesterday. Directly is responsible to principal. Clear, madam? Here, Anuj Naisik is not working for the Dharma. He is working for the, but is appointed by whom, beta? Dharma only. We discussed Esarna branch head, Banjarals branch head. Done. Done na? If he said, give it to me, నాకు ఇచ్చేయని చెప్పినప్పుడు డబ్బులు అప్పుడు సబ్ ఏజెంట్ అవుతాడు. వాడికి డైరెక్ట్లీ గివ్ ఇట్ టు ప్రిన్సిపల్. But here, pratyedi important before accounting the proceeds and remitting the same to Anuj. If this wording is not there, no, he might become substitute sub-agent because of this wording, changing the total meaning of the sentence. In the exam, knowing the concepts is different, writing the answer is different. Same question, beta. In the place of the, is changing the Azhar, Rahim. One more guy will be there. Aziz. Azhar, Aziz, Rahim. In the place of the Anuju, Dharma and Naisik. Same question. Next sentence. This question was asked 1, 2, 3, 4 times. How many times, sir? Mr. A of Alwar. Alwar is a city name, kind of Hyderabad. Mr. A of Alwar engaging S as his agent to buy the house. A is the principal. S is the agent. Why we are appointing this? To purchase the building. To purchase the. No. So S brought the house for 40 lakhs. How many lakhs, sir? He purchased the building for the 40 lakhs. In the name of the nominee. So S has to purchase the building on the name of A. But S purchased the building in the name of the S wife, Sweetie. Sweetie name is not given. S brought the house for 40 lakhs in the name of nominee. Then he purchased it for himself. So he purchased himself for how many lakhs, sir? 44 lakhs from his wife. Then sold the same thing to A for 46 lakhs. Actual billing value, but ultimately we are charging how much fraud is happened? 6 lakhs. How many lakhs? What's the worth of the building? 40. So he sold the same to A for 46 lakhs. A later came to know about the mischief made by S. So बाद में सब मालूम हो गया mischief of the S and tries to recover the excess amount paid to S. So how much excess we have paid? 6 lakhs. How many lakhs? So is A entitled to recover the amount from the S? Yes. And how much? 6 lakh. Explain. 1, 2, 3, 4 times I better. Actually, building value 40. Then he purchased in the name of his friend or wife or someone, nominee name, for 40 lakhs and selling to himself for the 44. Then selling it to principal for the total fraud. ऐसे कर सकते बेटा नहीं करना. So how much we can recover? 6 lakhs. So generally, agent should not make the fraud on the principal. If is making the fraud on the principal, principal can recover the amount from the agent. Step number 1. Step number 2. Step number 3. Comment on the statement. Principal is not always bound by the activities of the sub-agent. Principal is liable for the activities of sub-agent. Not liable. Properly appointed? Yes. Improperly appointed? No. Done. Clear. Anand. Listening? Arati. Arti. Arti is the wife. Not that much important pronunciation. Arti. And is the wife of Naresh. She purchased some sari. Sari luxury, comfort, necessary. Necessary. On the credit from the Measures Rainbow Silks, Jaipur. So Measures Rainbow Silks, Jaipur demanded the amount from Naresh. Naresh refused. Measures Rainbow Silks, Jaipur filed a suit against the Naresh for the said amount. Decide will she win or not. Yes, if they're living together. Living? 1, 2, 3, 4, 5 times. Sir. How many times, sir? Ara. We discussed, no, beta. They're living together, not living together. If they're purchasing for necessaries. Who is considered as an agent under the Indian Contract Act? What are the duties and obligations of the agent? Direct question. Who is agent? Duties of the agent. फटाफट लिख लेना बेटा कैसा? Direct question है ना बेटा? ये देखो देखो देखो. How many lines? So many lines. Rama directs Shyam. Rama directs Shyam to sell the laptop for him. Agrees to give Shyam 11% commission on the sale price fixed by the Rama on each laptop. So Rama is the principal. Shyam is the agent. He said, you sell the laptop, I will fix the price. So you will get 11% commission. How much commission? As the government of India putting restrictions on the import of the laptops, Rama thought that the price of the laptops may go up in the future. He revokes the Sham's authority for the further sale. A sale. For example, he is appointing in the month of the January till the December. In the month of the March, he is revoking. He said in the month of March, don't sell further. What about the sold laptops? Valid only, na beta. Sham before revoking the before receiving the letter at his end, he sold already 5 laptops. January, February, March, May. How many laptops he sold? At the price fixed by the Sham. Sham asked for 11% commission on the sale of the 5 laptops for each 1 lakh. Each 1 lakh. So how many laptops he sold? 5 into 1 lakh. Total amount of 5 lakhs into 11%. 55,000. So how much we have to give to agent? Sam asked for 11% commission on the sale of the file abstract for 1 lakh each. Explain under the provisions of the Indian Contract Act whether sale of laptops after revocation of authority is binding on Rama. No, we can't sell after revocation. That is in the month of after March. We should not sell. Then March is not given in the exam. We are assuming whether Sham will be able to recover the commission from Rama. Yes. If yes, what is the amount of commission? 5 lakhs into 11%. That is 55,000. How much, beta? Done. Next heading, beta. Personal liability anta. When agent is personally liable. When agent is personally liable, we discussed yesterday. 1, 2, 3, 4, 5 times in the exam. That question. Done. ఏం చేస్తున్నావు? What are you doing? An agent is neither personally liable nor he personally enforce the contract on behalf of the principal. Agent is neither personally liable nor he can personally enforce the contract on behalf of the principal. So can agent work on behalf of the principal? Yes. ఇక్కడ ఏమి ఇచ్చిండు? Neither. Answer is statement is wrong statement. The agent must act representative capacity and power to bind the principal. Even agent is doing, who will be liable? Principal will be liable. Then what test can be applied to determine the person is an agent or not? He is asking essentials of the agency. That question. Next, agency by ratification. That question. 1, 2, 3. I said yesterday to keep stars for the essentials of ratification. Petla? Next question. Agency by estoppel anta. Done. R of New Delhi sends his agent M to purchase certain goods from Globe Enterprises, Mumbai on credit for him. So, there is a person called R. He is sending M to purchase goods from the Globe Enterprises on credit basis. Which basis? Who is buying M from Globe Enterprises on credit? On credit. Later, R pays the amount for the goods purchased. R is paying the amount to Global Enterprises. On another occasion, second time, he is sending the M to purchase the goods, but this time he pays sufficient money, sufficient cash to M. Second time also, R is sending the M to purchase goods from the Global Enterprise, but this time he is giving the cash. M, however, again purchase the goods from Global Enterprises on the credit. Second time also buying on the credit. Soon after, agent mar gaya. Global Enterprise file a suit against the R for recovery of the amount. Can R is liable to pay the Global Enterprise? We discuss this example. We sell something in the Koti, SR Nagar. We purchase the goods from the Koti. So whenever subsequently agent become insane, sees in the white chudar, black chudar, he become crazy. Then we said to restricting the authority of the agent. Agent, you should not purchase the goods. Third party no, third party don't know. Whether third party know about the restriction, whether third party know that R is giving the cash? No, third party is ignorant. Whether the principal is liable third party or not? So last time agent is purchased. Who paid the money? R. Second time also agent is purchased. Who is liable to pay? Principal is supposed to pay. But what? Second time he is giving the cash. Who is eating that cash? Agent. But third party is in this one, na beta. Done na? Same thing we discussed yesterday. Third party has knowledge about the restriction. Third party don't know about the restriction. Clear? Kind of. Done. So, Global Enterprise will succeed to file a case on the R to recover the amount. Because first time you have paid, second time also I think you will pay. But second time he paid the cash. Who is eating the cash? Agent. Whose fault is that? Principal fault or agent fault? Agent is eating. Last question. this was asked twice, 2008 and 2020 RTP. And P appointing A as his agent. P means principal, A means agent as the agent to sell his estate, to sell the building. A, on looking over the estate before selling it, finds the existence of the good quality granite mine in the estate. So agent, so whose land is that? P land. So A went there for selling the land. When he is checking the land, no, A realized there was a mine in the land. There was a, so whether agent has to inform the principal? Yes, but he's not informing. So A, looking over the estate before selling it, finds existence of the good quality granite mine on the estate, which unknown to P. So, but who know? Agent. Whether we have to inform the principal, but whether he is informing, Chuddam. A buys the estate for himself after informing P that A wishes to buy the estate for himself, but conceals the existence of the granite. Donga. Who is Donga? A. So who is buying that land? A only. Without informing the, by concealing the granite mine. So P allows A to buy the estate in ignorance of the existence of the mine. State with reasons in brief the rights of the P, the principal, against the A agent. So can he file a case on the agent to recover that mine value? Yes, because it is the duty of the agent to be faithful to principal. Whether he is faithful, no. Then so principal can file a case on the agent to recover the mine value. Which value? Next question is the same question. What would be your answer if A had informed P? Second question. A had informed P about the existence of the mine before he purchases the estate, but after 2 months he sold the estate at a profit of the 1 lakh. So A is already informed P, in your land mine is there. Still I want to purchase. So P sold the land to A. Can he recover the mine? Can he recover the money from the A now? No, because we already informed about the mine. Two cases are there. First case, agent is not informing about the mine. So agent is defaulted. P can file a case. Second case, agent is informing. Still P sold the mine, that land. So in the second case, can he recover? No. Then so with this, we have done with the case 1, case 2. First case. So P can cancel the contract. Repudiate means cancel. Second case, he cannot cancel the contract because already been informed. Then so we have seen nearly how many questions beta? 27. 27 into 4. Nearly 100 plus questions we discussed only on the agency because age question was coming 3-4 times. Done. Nearly 100 questions. Do you think something else will come in the exam? To the best of my knowledge, this is more than sufficient if you prepare properly. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. Done. Yeah. So welcome back, sir. Let us do the contract of guarantee. Contract of explain the following. Ask the provisions of the Indian contract. Enumerate means explain. First one, meaning of contract of guarantee. Definition beta. It's a contract to perform the liability of a third party in case of default made by third party. Parties to contract of guarantee. Three parties will be there: surety, principal debtor, and who is given the guarantee? Surety. On whose behalf it is given? Principal debtor. To whom it is given? Creditor. Next question, beta. This was asked twice in the exam, 13 and 23, 10 years gap. Generally, if luck is good, after 10 years, paper will repeat. If luck is good. So, specific guarantee given for the single transaction, it cannot be revoked also. Next one is the continuing guarantee given for the series of transactions, maybe 4 marks, 2 plus 2 marks. Next, what are the rights of the indemnity holder? Just now we discussed. Hai na? All the damages, all the cost, and all other sums involved. Clear? Next, define contract of indemnity and contract of guarantee. State the conditions when guarantee is deemed to be invalid. So, if there is misrepresentation of the facts are there, but misrepresentation of facts, guarantee will be invalid. He is asking what is indemnity, what is guarantee, when guarantee will be invalid. 3 questions. How many questions, sir? Next question beta, from here practical question starts. ये देखो 1 2 3 4 5 6 7 8 9 times आया. Same question as it is. How many times sir? 9 times. So that means you should read this question 9 times when you're reading. That will sit in your mind. पढ़ेंगे बेटा. क्या करेंगे? Mr. X is employed as a cashier. Discussed this example. Cashier. Navadip. X is employed the cashier on the monthly salary of the 12,000 by ABC Bank for the period of the 3 years. है ना बेटा? Y gave the surety for X good conduct. Who's good conduct? X good conduct. Who's given the guarantee? Y. है बेटा? To the whom बेटा? ABC Bank. Which bank? ABC. For how many years is joined बेटा? Salary कितना? After 9 months, the financial position of the bank deteriorates, and X agrees to accept the lower salary of the 10,000, 10,500. Actual salary 12. Without informing to surety, they're making it as a 10,500. Without they inform it to surety, then what he will get? Angry. Yes sir, no sir. Ask then X agrees to accept the lower salary of 10,500 per month from the bank. 2 months later, it was found that X was misappropriating the cash. इन्हें गलत कर दिया बेटा X. Since the time of his appointment, what will be the validity of the, what is the liability of the X? Why? Surety. When he is appointed, date he is not giving. You know, beta. First 9 months and next 9 months. Because after 9 months, the converting the salary 12k into 10,005. But from when he is doing that fraud from the day one, from date of his appointment, from date of his so till the date of alteration, whether Y is liable, after alteration of the salary, whether Y is liable, is the answer. Generally, fidelity guarantee is a guarantee given for the good conduct of the person. But if there is any variation in the terms without the consent of the surety, he will be discharged. He will be step number 1. Here, surety will be discharged as to transaction subsequent to change. When it was changed after 9 months. How many months? Done. That will be the decision. Step number 3. This question was asked nearly 9 to 10 times in the exam. As it is. So, how much depth you have to study? That is up to you. Next question was asked twice in the exam, 2006, and I said test your knowledge. Explain the provisions of the Indian Contract Act 1872. Answer the following. A contracts with B for a fixed price to construct a house for B within the stipulated time. B would supply the necessary material to be used in the construction. Who is given the guarantee for that? C is given the guarantee for the A's performance. A, who is B? Creditor. Who is A? Principal debtor. Who is C? A contracts with B for a fixed price to construct a house for B. Yes sir, no sir. He is a masonry, he is a building constructing. And who has supplied the raw material? B should supply the raw material to that masonry. Who is the masonry? A. C guarantees the A's performance. So C said he will construct nicely. If not, I will pay the money. B does not supply material as per the agreement. Whether B is supplying, whether A is agreeing for that, yes. Then C will be. So B does not supply the material as per the agreement. Is C is discharged? Discharged or not discharged? Because when I am giving a guarantee, you have to perform the agreement as per the contract. Yes sir, no sir. So contract between the creditor and principal debtor will be discharged when this guy is not following the agreement. As per the agreement, you got supply material, but you are not supplying. So C will be discharged. Surety will be. Why? Because B does not supply the material as per the agreement. Since you are not following the agreement, I will be discharged. This question came twice. When how many times? Next question 2021 में आया बेटा. Satya has given his residential property on rent amounting to 25,000 rupees per month to Tushar. Amit become the surety for the payment. Satya has given residential property on rent to 25,000 rupees to Tushar. Satya. Amit become the surety. Amit become the surety for the payment of the rent by Tushar. Tushar will make the payment. If not, I will pay. Subsequently, without Amit's consent, Tushar agreed to pay the higher rent. Which rent? Without the consent of the surety, they change in the agreement. They are changing the. Amit will be discharged. So few months later, Tushar is defaulted. Who is not paying the rent? Tushar. Whether Amit is liable? No. Amit will be discharged from the date of the change in the rent, including same question 6th to 7th, 10 times. How many times, sir? Examine the meaning of the contract guarantee. We should get the meaning and position of the Amits in this regard. Amit will be discharged. Amit will be from the date of change in the rent. Then why advances Z alone? Who is giving the loan, beta? Y. To whom? Z. Y advances Z a loan of 10k on the guarantee of the X. Surety, creditor, principal debtor. Done. At an interest of 10%. Interest of 10%. Subsequently, Z has having some financial problems. Who is having problems? Z, principal debtor. Why reduce the rate of interest? Why reduce the, whether the same thing is informed to surety? No. And also extend the time period also. Increasing the time also without the consent of the X. X को क्या आता? गुस्सा. X will be discharged. Same question, no? 11th time. How many times? 11 times. 6, 7, 8 are same. If you observe keenly. Next one. In the absence of the contract, co-sureties are liable equivalent. So D was in urgent need of the money amounting to 5 lakhs. He asked K for the money. So who is giving the money? K. To whom? D. Mr. K lent the money on the surety of the A and B. Who are the co-sureties? Without any contract between them. So how much they are giving, beta? 5 lakhs. So how much A is guarantee? Don't know. B is guarantee? Don't know. When agreement is signed, how they have to share? I said star star superstar while giving a lecture. So without agreement, then in case of default in repayment of money by D to K, D made a default. B refused to contribute. Examine whether B can escape liability. B cannot escape liability. B and A has to contribute equally. B cannot contribute all the N would. Okay, in another question there might be N because this might be asked 1 2 times. A and B only, na beta. So A and B has to share equally. Done. This may be another attempt. So I'm merging the attempts, na beta. So that's why merging the attempts, na. So that's why you may get the different answer. The names may be different. Next, A agrees to sell B goods on the guarantee of the C. Who's selling? A. To whom? B. On the guarantee of C. Surety, creditor, principal debtor. That writing is very important. Making the triangle, keeping the same parts at the same time is very important. We should place them properly. Who's surety, who's creditor, who's debtor, you should understand clearly. A agrees to sell. Selling means giving. So, guarantee of C for payment of the price of goods. In case of default made by B, is the agreement is valid in each of the following cases. If A is minor, A is minor, A is minor, he must be competent to enter into contract. Agreement will be void. If B is minor, he can be incompetent to enter into contract. It will be valid. He must be competent to enter into contract. It will be void. Cheppunam before written. He may be, he may not be may or may not be competent to enter into contract, but other parties must be competent to enter into contract because it's a primary agreement. This is a primary contract, no, but both of them must be competent to enter into contract. Then next, contract of indemnity anta. Contract of indemnity anta. S ask R to beat T anta. S is asking R to beat T and promise to indemnify the R against the consequences. And I said to Rajini beat the Gautami. If Gautami files a case, I will take care of you. Yes or no, sir? Is lawful agreement? Unlawful agreement. Objective is unlawful objective. Beating. So, indemnify the R against the consequences. R is beating the T, which is unlawful, and find the 50k. Can R claim the 50k from the S? Answer is no, but it is unlawful activity. Which activity? A few students will write about the coercion here because beating is there. No, but there's nothing. We have to understand from which point of time, from which point of what is the interest of the examiner. Next, Manoj guarantees Ranjan. Who is guaranteeing, beta? Manoj. Manoj guarantees Ranjan. Manoj Ranjan, a textile merchant, for the amount of 1 lakh, for which Sharma supplier may from time to time supply the goods on credit to Ranjan. Sharma supply. So for which Sharma the supplier may from time to time supply the goods on credit to Ranjan. So who is supplying Sharma? To whom? Ranjan. During the period of next 3 months. After 1 month, after how many months, beta? 3 months. After 1 month, Manoj revoking the guarantee. Who is revoking the guarantee? Manoj revoking the guarantee. When Sharma has already supplied the credit of 40. Before revocation, how much he has supplied already? 40. For 40, who is liable? Manoj will be liable. Manoj will be liable. Referring to provisions of the Indian Contract Act, whether Manoj is discharged from the on the liabilities. No. So for this liability, discharged. For this liability, liable. Then Manoj is discharged for the subsequent credits. Which credits? The liable to the Manoj for the previous transactions will remain. That is 40k. How much? Then discuss with this example in the class. Yes sir, no sir. Something we discussed last class. Next, C advances to B. Who is giving the money, beta? C. To whom? B. How much? 2 lakhs. On the guarantee of A. This writing triangle is very, very important. If you can able to draw the triangle properly in the exam, answer will be in your hands. Marks will be in your pocket. C advances to B 2 lakhs on the guarantee of the A. C also has taken the C has also taken further security for the same borrowing by a mortgage of the piece furniture worth of the 2 lakhs without the knowledge of the A. Without the knowledge of C also taken further security for the same borrowing. So about the security, who don't know? A don't know about the security. Furniture security, no matter mortgage of furniture. But who don't know about that? A. C cancels the mortgage after 6 months. After 6 months, B become insolvent. B become insolvent. C is filing a case on the A for his guarantee. Decide. Decide the liability of the A. If the market value of the furniture is only 80k under the provisions of the Indian Contract Act. What is the crux of the question here? Here, principal debtor and creditor hiding some information with A. What they are hiding? About the guarantee, about the security, about the whether security is there, security is not there, whether it is liability is affected. No. Yes sir, no sir. Amount is they are not manipulating. If their contract of guarantee is not utmost good faith, these two people can hide the immediate information. Which information? So actually, how much loan they are giving? 2 lakhs. So this guy is defaulted. What the worth of the furniture when we are giving 2 lakhs? What is the worth of the furniture on the date of the breach? ITK. So liability will be reduced by the ITK. So his liability will be only 1.2 lakhs. And the surety is entitled to get the benefit of the security which creditor has against it, whether he has knowledge of the surety or not. Surety is discharged to the extent of the value of the security. What is the value of the security? 2 lakhs. But on the date of sale, how much is that? IT. So how much is liable? 1 lakh 20 will be liable. Yes sir, no sir. Clear? Loan in the chinam 2 lakhs. On the date of the loan, what is the worth of the furniture? 2 lakhs only. But on the date of the breach, what is the worth of the security? ITK. So the liability will be reduced by the ITK. So his liability will be only. Right question, but a contract of indemnity versus contract of guarantee. This was asked 1, 2, 3, 4, 5, 6, 7, 8, 9 times. Nearly 10 times this was asked in the exam. Contract of guarantee versus contract of indemnity. Nearly 10 times. Nearly. Next question. Manish, a minor, lost his parents in COVID-19 pandemic. Due to poor financial background of Manish, due to poor financial background, Manish was facing difficulties in maintaining the livelihood. He approaches Mr. Sohel, a grocery shopkeeper, for supply him grocery items and to wait for some period for recovering the dues, receiving the dues or recovering the dues. So who is giving the groceries? Okay. To whom? Manish. Manish is a you give me the groceries right now. I will make the payment later. Done. इसके बाद क्या हुआ? Sohel did not agree for the proposal. Sohel said, sorry, without money I will not give. But when Ganesh, a local person who is a major, Ganesh, who is a major, agrees to provide the guarantee that he would pay the dues in case Manish fails to pay the amount. So Ganesh said, Are Sohel, give the articles to Manish. Manish will pay. If not, I will pay it to you. Abdul, sleeping, boring, doing something else. So Ganesh said, if we do not pay, I will pay. So he supplied the required articles to Mahesh. So because Ganesh is there, so he supplied. So surety, creditor, principal debtor. After a few months, when Manish fails to clear his dues, so Manish is unable to make the payment of Sohel. Sohel approaching Ganesh and asked him to clear the dues of Manish. Ganesh refused to pay the amount on two grounds. First ground, firstly, there was no consideration in the contract of guarantee. Consideration is there. Money given by the Sohel to Manish is the consideration to Ganesh. That thing we have tried. Next, secondly, that Manish is a minor. Manish is a minor. So principal debtor can be incompetent to enter into contract. So therefore, both the grounds contract of guarantee is invalid. Whether Ganesh is right in his contention? No, is not right. Referring to provisions of the Indian contract, decide whether contention of the Ganesh is tenable. It is not tenable. Tenable means acceptable. Tenable and acceptable. It is not acceptable. So money given, goods given by Sohel to Manish is the consideration to Ganesh. First thing is not valid. Second thing, Ganesh is arguing he is a minor, so I will not make the payment. So Act says principal debtor can be incompetent to enter into contract. So will your answer different in case both Manish and Ganesh are minors? He is a minor, he is a minor. Then agreement will be what? Agreement will be because minor will not have any liabilities. Minor cannot become surety at all. Then in the both second case, agreement will be void. Second case, first case, Ganesh will be liable. Ganesh is not liable. Then so you should do all these things in step number 1, step number 2, step number 3. Yes or no, sir? Clearly. Next, Paul, a minor, purchased a smartphone on credit from the mobile dealer on surety given by the jock. Who is the surety? Jock. Who is the principal debtor? Paul. Who is the creditor? Mobile shop. A shop? Mobile shop. The mobile dealer demanded the payment from the jock. Jock argued that he is not liable for the amount since Paul is not liable. He is the minor. Whether argument of the John is right, Jock is right, beta? Not right. What will be your answer if Jock, Paul both are minors? Then it will be void operation. Twice. You know what the same question can? Twice. How many times? 21, 24. Next, Ricky, the owner of the electric shop, Prisha, reaching the shop to purchase an air conditioner whose compressor should be of the copper. The Prisha wanted to purchase the air conditioner on the credit. Ricky demands a guarantee for the such transaction. Who is the supplier? Ricky. Who is the buyer? Prisha. What they're buying? AC. AC must contain the copper compressor. Instead, machine will be there. No, the machine should be of the copper. So Shiva, a friend of the Prisha, came forward and gave the guarantee. Who's giving the guarantee, beta? Shiva, for payment of the AC. Ricky sold the air conditioner of a particular brand, misprinting that the more it is it is made of the copper while it is made with the aluminium. Whose price is different? Copper AC will be 50k and aluminium AC will be only 30k. What is that? Misrepresentation. That misrepresentation is affecting the liability of the surety. Surety will be discharged. Neither Prisha nor Shiva had the knowledge of the fact that it was made with aluminium. On becoming aware of the facts, Prisha denied the payment of the price. Ricky filed a suit against the Shiv. Whether Shiva is liable? No, because there is a misrepresentation of the facts, which will affect the liability of the surety. This was asked 3 times. How many times, sir? Shiva will not be. Will not be. This question was asked 1, 2, 3, 4 times. How many times, sir? Above AC is there, here filter is there. Yes or no, sir? So, same question, sir. That 17th one and 18th, 1, 2, 3, and this one is the 4th time, including 20, 24. When beta? Please do this scanner. Scanner को use करके पी लेना बेटा. Done. I don't have time. I don't want to write. वो आपका मर्जी बेटा. शादी में नहीं होता. Examine the validity of the following statements under the provisions of the Indian Contract Act. Creditor should proceed legal action first against the principal debtor, later against the surety. Whether I said like that, first surety में the case है, first principal debtor में case है. Whether I said like that, no. We can file a case on surety, we can file a case on the creditor, we can file a case on both of them. Is there any step by filing is there? No. So it is not mandatory that first we have to file the creditor surety only. No, we can file anyone. So a guarantee which extends to single debt is called as the continuing guarantee. Wrong anta. It is not a specific guarantee. Which guarantee? Single transaction ke chede. Next, Surendra guarantees Virendra for the transaction to be done between the Virendra and Jitendra. Virendra supplied goods to Jitendra. Guarantee given by Surendra. Yeah. Virendra supplied goods for the $30,000 on 1/3/21 and $20,000 on 3/3/21. Two transactions are there, beta. It is given by the Surendra. On 5/3/21, Surendra died. मार गया on road accident. So before his death, how much was supplied already? 50. 30 plus 20, 50. On 10/3/21, being ignorant of the death of the Surendra, Virendra further supplied 40. For this, whether surety is liable? For this, whether surety is liable? Yes. On default in payment by Jitendra, oh jump हो गया बेटा. वीरेंद्र sued the legal representative of the Surendra. उसका बेटा को filed a case for the recovery of the 90K. For recovery of the but 50 plus 40. First of all, surety is not able for this 40, only for this 90. Describe the whether legal heads of the Surendra are liable to pay 90K under the provisions of the Indian Contract Act. Yes. What will be your answer if the estate of the Surendra is only 45? So, वो सुरेंद्र का बेटा है ना बेटा, लाइबिलिटी कितना आया 50, एसेट कितना आया 45. So बेटा क्या क्या कितना देता 45 देता. So actually Surendra's son will be liable for the 50. However, Surendra's son will not be liable if the estate given by father is not 50. Yes sir, no sir. తండ్రి నుంచి ఎంత వచ్చింది కొడుక్కి 45 వచ్చింది సెకండ్ కేసులో. ఫస్ట్ కేసు రిజల్ట్. First case, whether legal heirs of the Surendra is liable to pay 90? No, liable to pay 50. Clear? Second case, what will be your answer in case estate of the Surendra is worth of 45? So, from the son of the Surendra, how much property is getting? 45. From the Surendra, how much loan is getting? 50. If estate of the deceased person is legal representative of deceased person will be liable only to the extent of estate received from deceased person. The worth of the estate is only 45. Legal heirs are liable only for the 45. Done. So this kind of things we can able to know if you do the scanner. Same question beta. Suraj, Vikas and Nikhil. Above question same as it is. 2022 and also the 2024 as it is. Next question beta. This question was asked in 23. Mr. Salil purchased furniture worth of 1K, 1 lakh from the Puran on the creditor. Raman entered into contract with Puran for guarantee of the payment by the Salil on due date. Crazy fellow. On due date, Salil could not make the payment due to financial crisis. Mr. Puran filed a suit against the Raman. Filed a suit against Raman for the payment. Meanwhile, father of Salil paid how much? Worth actually 1 lakh. How much beta? 1 lakh. Meanwhile, Salil father paid how much beta? 20 on behalf of his son. So Raman liability reduced to IT. We discussed that. So Raman is ignorance of the above payment. He paid 1 lakh to Puran. To Puran as surety. Afterwards, Raman came to know the facts. He asked the Puran to refund of the 20. Whether he should refund the 20 or not? Yes. Mr. Puran denied for refund with the words that that's only Salil who can claim the amount from 20. So explain the different provisions of the Indian Contract Act. Puran, this guy, surety can recover the 20K from the creditor. Reduction the value of the liability. Done. Bolo. So liability to surety is equal to liability of the principal debtor. His liability is kitna beta? 80 only because 20 paid by whom? Papa. Who's Papa? we can claim. See, understanding is very, very important question. We have to keep the eyes on the question. You have to read slowly. Then next question, beta. Then so shall we do remaining part? Remaining part we'll discuss in the next class. Have a great time. Enjoy the day. Prepare well. అస్తుంటారా? Welcome back, sir. In the last class, we discussed till the question number 22. Next question, question 23. Mr. Sanjeev is dealing in high quality timber. Which timber, beta? High quality timber. Timber means wood. Timber means wood business. Chekka. So, Mr. Amit wants to purchase. There is a person called Sanjeev, the seller of the timber. Amit wants to purchase the timber from him. From him on credit, which is to be used in renovation of his house. So Pramod gives the guarantee to the Sanjeev for timber to be supplied by Sanjeev to Amit. So who's selling? Who's buying? Who's giving the guarantee? Creditor, principal debtor. Sanjeev supplied required timber to Amit. Sanjeev supplied the timber to Amit. Afterwards, Amit embarrassed and contracts with creditors, including Sanjeev, to assign them his property in consideration of releasing him from the demand. Afterwards, Amit embarrassed and contracts with the creditors. Amit entered a contract with the creditors, including Sanjeev, to assign them his property. Principal debtor said to creditor, Sanjeev, I don't have money. Instead of the money, I will give you my property. Assign them property in consideration of their dealings, releasing him from their demands. So, what is the worth of the timber? For example, 50 lakhs. How much? 50 lakhs. So, Amit said, sorry, I can't pay the money. You can take my land worth of 50 lakhs and release me. You take my property and release me. Take my property, land, release from the debtor. On due date, Sanjeev filed a suit against the Pramod for recovery of the payment. On due date, Sanjeev filed a case on the Pramod for recovery of the amount of the timber due to Amit. Explained with reference to provisions of the Indian contractor, Mr. Sanjeev can claim the amount from Pramod. Can S file a case on P? Why? I need the property, no beta. So what is the worth of the wood? 50 lakhs. For that amount, already I have the property, no beta. When principal debtor is discharged, automatically surety will be discharged. Then Sanjeev cannot claim the payment from the Pramod because when principal debtor is discharged by paying the property, by giving the property, surety will also be discharged because liability of the surety is equal to liability of the principal debtor. Liability of the principal debtor is zero because instead of the money I am giving my property. Then, any doubt here? Next question 21 may I become. See, if you are observing, questions are more depth in this chapter. Bailment to pledge agency questions are more depth comparatively. Nowadays is focusing on these chapters only. That's why I said when I started the bailment, Read it immediately. Cheppana? Next. Answer is easy, but understand the question is not that much easy. Understand the question. Due to urgent need of money amounting to 3 lakhs, Pavan approaching Raman and asked him, P for Pavan, P for poor, R for Raman, R for rich. He's following my strategy. Approaching Raman and asked him for the money. Raman lent money on the guarantee of the Suraj. S for Suraj, S for surety. The 3 sureties are there. Suraju, Tarunu, Usha. But S for surety. Yes sir, no sir. Any Usha is there in the class? Where is the Usha? Ushasri. Ushasri, can you ask me a question? Who is giving the money? Raman. To whom it is given? Pavan. Principal data. Who is the giving surety? Suraj, Taran, Usha. Clear. Pavan makes a default in payment and Suraj pays full amount to Raman. So Pavan defaulted. Pavan defaulted. So everything is paid by whom beta? Suraj to Raman. Suraj to Raman. Raman give money, he is getting back his amount also. Suraj afterwards claimed the contribution from the Tarun and Usha. Asking the money from the Tarun and Usha. Contribution from Tarun and Usha. But they refused to contribute on the basis that there is no contract between Suraj and them. So, but they said that we don't want to make the payment because there is no agreement. There is no, when there is no agreement, how they have to share? How they have to share? Super, mind blowing. Someone said in the first bench. So, co-sureties in the absence of contact between them, they have to share. So, how much Suraj is paying to this Raman? 3 lakhs. How many lakhs? Sir? So, Suraj can take 1 lakh from the Tarun, 1 lakh from the done. That's it. Next, Alpha Motors Limited agrees to sell bike to Ashok under hire purchase agreement on the guarantee given by Abhishek. Who's selling the car? Alpha. To whom? Ashok. Who's giving the guarantee? Abhishek. Abhishek. The terms were the hire purchase price of 96,000 payable in 24 monthly installments of 8,000. What is the worth of the bike? This 96,000 we have to pay in 24 installments. 24 into 8 is equal to 96. 96. The ownership is to be transferred on payment of the last installment. When you pay the 24th installment, ownership will be transferred on the bike. Done. State whether Abhishek is discharged in the following alternative cases under the provisions of the Indian Contract Act. Whether Abhishek is discharged. Abhishek is a surety. Abhishek is the Ashok paid 12 installments. Ashok paid 12 installments, but fails to pay the next 2 installments. Alpha Motors sued Abhishek for the payment of the arrears. Abhishek paid these 2 installments on that is 13th and 14th. Abhishek then gave the notice to Alpha Motors Limited to revoke his guarantee for the remaining months. So 13, 14, who has paid better? First 12, who paid? Ashok. Ashok divided. Ashok paid the first 12 months. 13, 14, who paid? Abhishek. Then he said, don't sell anything from tomorrow. We discuss same thing. SG Kirana shop, somebody's son is coming to my shop every day. So he said, don't give from tomorrow. I remember. So after 14, whether surety is liable, not liable. 2 marks. If after 15 months, Abhishek died. Who died beta? Abhishek. Abhishek means surety. By death of the surety, contract of guarantee comes to an end for the future transactions. Which transactions, sir? Yes. Previous transactions, his estate will be liable. What is liable? Done. Death of surety will opt as a revocation of the continuing guarantee as to future transaction. Then, sir, we should have everything as it is in the exam. What green things are there? No, provision है बेटा. Other things you can change to some extent. You need it by heart. Understand. Don't focus on by hearting. By heart only the provision. Provision also definition is about by heart. Other than that, use the technical words and write it. So other things are there, no, but this thing and this thing. You cannot your own words, but professional words. Then we are human beings. We are not Xerox machines. But definitions I say likhna beta. But it has to match. Clear? Same question. I see giving the in another attempt. 90% will remain same. 10% variation will be there in the IC answer also from attempt to attempt. Because drafted by different person. Done? Yeah. But one thing is very, very important. Cumulative results are mandatory. When you're doing the 7th chapter, don't leave first chapter. It's like your parents. Yes or no, sir? Question number 26. S guarantees V for the transactions between V and B during the month of March. We supplied goods. Who supplied goods, beta? Supplied goods. To whom, beta? B. Who is the surety? S. We supplied goods of 30,000 rupees on 1st March 22. This was asked in 23 and 22 and 20,000 on 1st March, 3rd March to be. So, how much we supplied? We gada. So, who is supplying beta? B. To whom? B. Surety? Yes. How much we supplied to B? 50k. 30 plus 20? 50k. That is on the 1st March and 3rd March. On 5th March, this was happened before death. Beta? So on 5th March, S died. Who died, beta? Yes. After 5th, whether S is liable? No. But before death, S estate is liable. S estate. On 10/1/22, being ignorant of the death of the S, we further supplied the goods of 40. Whether for this 40, whether estate is liable? No. Even you don't know about the death. On default in payment by B, on due date, B sued legal heads of S for recovery of the 90. That is above 50 plus 40. 30 plus 20 plus 40. Pura milke 90. So, where is B? Yes, the LR is liable only to the extent of the 50. Because this was supplied before his death. Then, read slowly when you're reading the question. We sued the legal heads for 90. Describe whether legal heads of S are liable to pay 90. No, they are liable to pay only 50 because before his death only 50 is transferred. Under the provisions of Indian. What will be your answer if the estate of the S is only 45? Is liable only to the extent of the 45. We discussed same question yesterday, I think. As it is. Then చేసామా yesterday? చేసామా? A stands surety for B for A stands surety for B for any amount which C may lend to B. Who is lending? C. To whom? B. For that, who is giving the guarantee? A. From time to time during the 3 months, subject to maximum of 50. His guarantee is giving only for the maximum of the 50. Different to provisions of the Indian Contract Act decide whether A is discharged from all the liabilities. Whether A is discharged from all the liabilities to C subsequent to loan anta. We forgot this one. 1 month later, we forgot this line. 1 month later, A revokes the guarantee when C all lend 5,000 rupees. Actually, guarantee is going for how many months? 3 months. After 1 month, he is revoking. By that time, how much we transferred? 5,000. For this 5,000, who is liable? A will be liable. Next. decide whether age differs from all liabilities to see subsequent to for any subsequent loan. Yes, A will be discharged for all the subsequent loans, but prior loans liable, subsequent loans not liable. Sir, able to understand? When he is working better? After 1 month. After 1 month, if we see supplying to be whether age supplyable? No, because he is revoking. How much age liable? Only 5,000, which was supplied before revocation. Before, what would be your answer in case B makes a default in paying back C? ఏంటంటే what will be your answer in case B makes a default in paying back to C and the money already borrowed 5,000 rupees? Then who is liable for that 5,000 rupees? A is liable. Who is liable? Then already supply చేసాం 5,000. If A is not, B is not giving, then who will be liable? Only 5,000. Only. Sir, able to understand the questions? Able to understand the questions? I am reading very slowly. Next question, beta. Ravi becomes guarantor for Ashok anta. Ravi becomes guarantor for Ashok for the amount which may be given to him by Nalin. Who is giving the money? Nalin. To whom? Ashok. Who is the guarantor? Nalin. For the 6 months. How many months? Continuing guarantee. The maximum limit of the said amount is 1 lakh. How much is the guarantee? 1 lakh. After 2 months, same question. After 2 months, it is given for the 6 months. How many months? 6 months. After 2 months, up to the he revokes the guarantee. Up to the time of revocation of guarantee, none already supplied 20. How much? 20. For this 20, who will be liable? R will be liable. If he is unable to pay. Same question. 27, 28 as it is. Then same. 29. Same, Same. Twenty-seven, 28, 29 are the same. Then repeat or na? A gives C a continuing guarantee. Which guarantee? Continuing guarantee to the extent of 5,000 for the vegetables to be supplied by C to B. Supplied by C to B. Who is the guarantor? A is the guarantor. Afterwards, B become embarrassed and without the knowledge of the A, B and C contract that C shall continue to supply the B with vegetables for ready money. Which money? So when you give the money, I will give the payment. So that payment shall be applied to them existing debt between the B and C. So without the knowledge of the C, without the knowledge of the A, without the knowledge of the so B and C entering into a separate agreement, then A will be discharged. A will be variation made without the surety's consent. The principal debtor will be discharged. Then surety will be discharged. A will not be liable. A will not be liable after the new agreement. After the clear discharge of the contract. We discussed now. Same example. I said very, very important. Discharge. We kept so many stars. Yes or no? Then next question, 2018. Mr. D was in urgent need of the money amounting to 5 lakhs rupees. He asked K for the money. Mr. K lent the money. Same question we discussed. Urgent need of the money. Tarun, Usha. Same question repeated. Next, C advances to be 2 lakhs rupees on the guarantee of the A. C has also taken the further security of the same money. Discuss the same question. Sir. Furniture value 80,000 rupees. We discussed yesterday. Furniture. We discussed in the last class. Sandeep garments, guarantees. Sandeep guarantees for Gaurav a retail textile merchant for the amount of 1 lakh, for which Sharma, the supplier, may from time to time supply the goods on credit basis to Gaurav during 3 months. రాసుకుంటా ఇకనే బట్ ఆల్వేస్ 2020 में आया. Sandeep guarantees Gaurav a retail textile merchant for amount of 1 lakh, for which Sharma the supplier may from time to time supply the goods on credit basis to Gaurav. Who supplying? Sharma. To whom? Gaurav. Who is giving the guarantee? Sandeep. Next 3 months. How many months? Continuing guarantee for 3 months. After 1 month, Sandeep revokes the guarantee. When Sharma has supplied already 40k. For this 40k, who will be liable? Sandeep. If Gaurav is defaulting. Different provisions of the Indian contractor decide whether Sandeep is discharged from all the liabilities. No. He will discharge only for the subsequent dates. Same question discussed so many times. Explaining the provisions of the Indian Contract Act 1872 answer the following. A contracts with B for a fixed price to construct a house. We discussed yesterday supplying of the material, but she is not supplying the material. Beginning we discussed chesa. So surety will be discharged because the creditor is not supplying the material as per the agreement. Yes sir, no sir. 34 discussed. Discussed already. Mr. R extended a loan to D. Who is giving the loan? R. To him, D. With X, Y, Z are the sureties. X, Y, Z are the sureties. Each surety executed the bond with varying penalty amounts with X 10k, Y 20, Z 40. X ఎంత ఇచ్చిండు 10, Y ఎంత ఇచ్చిండు 20, Z ఎంత ఇచ్చిండు 40. In the event of this failure to pay the borrowed money to Mr. R, examine the liabilities of sureties in accordance with the Indian Contract Act. When D defaults 42,000, ఇంత డివైడ్ బై 3 చేయండి. 42 divided by 3 అమ్మా 14. But A liability only 10. Out of 42, 10 పోతే ఎంత వచ్చింది 32. Divided by 2 చేయండి. Divide by 2. So the how to say 16, 16. Yes sir, no sir. Clear? We discussed yesterday. X liable to pay 10, no? X, Y and Z has to pay 16, 16. Ganesh, come on. Claps for Ganesh. చెప్పినా ఆన్సర్ మామూలుగా గణేష్ అంటాడు. See, within that ceiling limit, everybody has share equal asset, na beta? How much loan he is giving actually? 42 defaulted. How they have to share generally equally. Equivalent ఎంత వస్తుంది 40 divided by 3 ఎంత వచ్చిందిరా 14. But actually his liability is only 10. So 42 minus 10. 42 minus 10. कितना आ गया बेटा 32. So who should share that? These two people. How much it is coming? 16, 16. So he is within the limit only. Done. So this question was asked in 2024. In Linko question another. Additionally, assess the situation if there is no contractual agreement between the these sureties. How they have to share beta? Equally. How they have to share? If there is no agreement like this. This amount is not there, but then they have to share equal. Done. Second case. That is 14, 14, 14. Due to urgent need of the money amounting to 3 lakhs, discussed already. Explain in brief referring to provisions of the Indian Contract Act 1872 what are the rights enjoyed by the surety against the creditor, principal debtor, co-sureties. Right question beta. Against creditor, against debtor, against co-sureties. That is the rate of subrogation, rate of set off, rate reduction sharing value. Right question. Next question. State the rights of indemnity holder. Right question. We can recover the cost involved and damages and all other expenses. Next question. Define contract of indemnity, contract of guarantee. State the conditions when guarantee is deemed to be invalid. This question also we discussed, I think, in the beginning. It is deemed to be invalid if there is misrepresentation of the facts. Done. Clear. So we discussed nearly 40 questions. How many? 40 into 3 times nearly 100 questions we have discussed. Even each question is coming 2-3 times. No, but nearly 100 questions we discussed only on the contract of guarantee. Do you think something else will come in the exam beyond this? To the best of my knowledge, nothing will go beyond this discussion. Done. So have a great time. Enjoy the day. Prepare well. SG signing off. Take care. So in the next class, we will be starting the Stoga. Ega.